You know, this was a short session, and as a short session, and there wasn't a buzz about too many things. I mean, we had about the personal tax and that type of thing, but still I thought, well, it's not going to be so bad this year. There was a lot of little things all over the place. That's what I discovered. So in some ways that made it even a little more difficult to pull together the new ledge. One thing I want to remind you of is that while this is focused on the laws that are impacting you, we also will have a county bulletin that pulls together all of the legislative information for all of the offices. So let's get started. Senate Enrolled Act 53 amends IC 36-9-23-25, 32, 33, and 36-9-25-11, effective July 1, 2014, and it has to do with sewage liens. And this was really our cities and towns supervisor. He kind of wanted to let you know that when property is occupied by someone other than the property owner, before, even when it was rented out, delinquent fees were a lien against the property, but the lien attached at the time when notice of lien was filed with the recorder's office. Now, an ordinance may be passed by the legislative body so that the fees assessed against the property do not constitute a lien against the property. So you might be seeing fewer liens this way. So that's kind of informational. Senate Enrolled 61 is IC 5-10-17 is a new chapter added effective July 1, 2014. This is under Public Employee Benefits and applies to emergency medical services providers employed by a county. Under IC 16-41-10-1, it defines an emergency medical services provider. Means a firefighter, a law enforcement officer, a paramedic, an emergency medical technician, a physician, and a nurse or other person who provides emergency medical services in the course of the person's employment. A county may provide disability insurance to its emergency workers who become disabled as the result of an injury or illness, and that they're not covered by workers' compensation, which would be as defined under Indiana Code 22-3-2, or workers' occupational diseases compensation, which is defined under IC 22-3-7, or of which coverage under workers' compensation or workers' occupational diseases compensation has been exhausted. A program that is established under this subsection may not have an elimination or waiting period for benefits to begin, and may not be greater than 30 days for a short-term disability program or 120 days for a long-term disability program. A county may provide disability insurance through either by purchasing policies of group insurance, by establishing a self-insurance program. If it's a self-insurance, then the fiscal body must approve, and you may exclude from under coverage from this program disability insurance for emergency medical service provider who is a part-time employee as defined by your policy, or provide services under contract. So this is a new benefit that can be provided to any of your emergency services workers. Senate Enrolled Act 118 amends IC 36-7-14 effective July 1, 2014. This chapter is about redevelopment commissions and departments of redevelopment. Really, SBOA and DLGF, per the statute, make the rules and prescribed forms and procedures considered expedient to implement this chapter, and there were many changes about this, like things about ownership of single-family homes and transfer and sale of properties. Michael Duffy will be going over a lot of these tomorrow. I just wanted to discuss two areas. First, that under Indiana Code 36-7-14-3, there were specifics that were added. I don't know that it really changed things so much as it just it clarified it. It now specifically states that these commissions and departments of redevelopment are subject to oversight by the legislative body, including a review of the budget, audit by State Board of Accounts, we always thought we could, and covered by public meeting laws and covered by public records law. The other change is under IC 36-7-14-8. This is in regard to who is the treasurer for the Redevelopment Commission. Before it said that the Redevelopment Commission may appoint a treasurer who need not be a member of the Redevelopment Commission. The Redevelopment Commission may provide for the payment of compensation to a treasurer who is not a member of that commission, and notwithstanding any other provision, the treasurer has charge over and is responsible for the administration, investment, and disbursement of all funds and accounts of the commission in accordance with the chapter. However, the treasurer may not perform any duties of the fiscal officer or any other officer of the unit. So there was definitely a ability on the commission's side to be able to hire a treasurer. Now it states that the fiscal officer of the unit establishing a redevelopment commission is the treasurer of the Redevelopment Commission. And notwithstanding any other provision, the treasurer has charge over and is responsible for the administration, investment, and disbursement of all funds and accounts of the Redevelopment Commission in accordance with state laws that apply to other funds and accounts administered by the fiscal officer. And the treasurer shall annually report to the fiscal body of the unit before July 1. Yes? We get paid for that? It does not say that. It is not, yeah. Might want to be talking to your ledge people. So now, depending on the law, the fiscal officer is considered the auditor or the treasurer, and it's our position that the treasurer and an auditor must work in the same manner that they normally would, with the auditor, of course, accounting and dispersing, and the treasurer doing the investment. So it is kind of a split duty between the offices. Because I'm sure you don't want to take over investment duties, do you? No. Oops. Senate Enrolled Act 208, I know we're kind of out of sync, but it's not backing up for me. It amends IC 5-14-3-4, effective upon passage. This has to do with public records. Under this, statute, there's an exclusionary statute for items that can't be disclosed, such as Social Security numbers. And then there's also a discretionary section, which is where this has been added. And it's to some items that go to the unclaimed property report to the AG, and at the discretion of the public agency, it gives the following items that may be excluded, such as date of birth, driver's license number, etc. Senate Enrolled Act 225 amends IC 5-10-8-2.2, 2.6, and 5-10-8-6.6, effective July 1, 2014. And it repeals the local unit participation in the state of Indiana insurance plans, including the health care coverage. Senate Enrolled Act 229 adds IC 35-47-3.5, effective July 1, 2014. And this has to do with the firearm buyback program. And this is where sheriff might want to have purchased privately owned firearms from individuals. We've all heard of those programs. And this is just making it clear that you may not use public funds, that it's either grant monies or private funds to do this. So let your sheriff know. House Enrolled Act 1178 amends IC 36-1-8.5-3, effective July 1, 2014. This has to do with restricted addresses. And this is where it allows, it does not require, that a county that operates or contracts for a public internet website database containing the name and addresses of property owners to establish a procedure to permit a law enforcement officer, judge, or victim of domestic violence to restrict disclosure to the general public of these persons' home addresses upon their request. So this is a choice. This was discussed last year, but it's going into effect for July 1, 2014, that federal judges are also included in that. I kind of took that if it's a judge, it was a judge, but I guess they want to make sure that you know that it's federal judges too. Senate Enrolled Act 249 amends IC 6-1.1-25-2, subsection C and D, effective July 1, 2014. The total amount required for redemption of real property has changed based on whether the date of sale was before July 1, 2014 or after June 30, 2014. Nothing has changed for the base minimum bid amount. 110% of the amount must be paid if redeemed not more than 6 months after the date of sale, or if more than 6 months, it's still 115% of the minimum. The change has come for that portion that exceeds the minimum bid. The amount exceeding minimum bid must be paid plus the 10% per annum on the amount by which the price exceeds the minimum bid if the date of sale is before July 1, 2014. And then the change is, if it's after June 30, 2014, that the amount exceeding would be plus 5% per annum of that amount. Also, the total amount required for redemption, including all taxes and special assessments upon the property paid by the purchaser after the sale, plus 5% per annum on those taxes if the sale occurs after June 30, 2014, versus the 10% that was before July 1st. Also amends IC 6-1.1-37-17, effective July 1, When the auditor determines that property not eligible for standard deduction for homestead, the auditor will notify the county treasurer, and here's the new part, do one of the following. Make a notation on the tax duplicate that the property is ineligible for the standard deduction and indicate the date of the notation is made, or record a notice of an ineligible homestead lien in the recorder's office. And the recorders want you to know this without charge. So they're not going to argue with you. The additional taxes and civil penalties that result from the removal of the deduction are imposed for property taxes first due and payable for an assessment date occurring before the earlier of either the date of the notation made on the tax duplicate or the date of the notice of the lien recorded. This part has not changed. The county auditor issues a notices of taxes, interest, and penalties that require full payment within the 30 days. That part hasn't changed. And if it's not collected by the due date, it is subject to collection under one of these. After being placed on the tax duplicate, it's collected in the same manner as other property taxes. New part is through a notice of ineligible homestead lien recorded in the county recorder's office. Property subject to a determination made under this subsection that is owned by a purchaser without knowledge of the determination, no lien for any additional taxes and civil penalties that result from the removal of the deduction is required there. So that's something new that you need to keep in mind. Upon the release of the lien or collection of the amount, the county auditor will submit the appropriate documentation to the recorder, who will amend the information recorded, again, without charge. Senate Enrolled Act 249 also adds IC 32-21-7-1, subsection B, provides that a governmental entity may claim title by adverse possession without having paid property taxes and special assessments due on the property if the governmental entity is exempt from the property or payment of property taxes and special assessments. And it states that a governmental entity may claim title to real property by adverse possession without having paid all taxes and special assessments due on the real property during the period of adverse possession if it was exempt from doing so. So I think that was a bit of a clarification. Senate Enrolled Act 249 and 422 both cover this. Amends IC 6-1.1-25-4, specifies that a property tax penalty for property sold by county executive through a certificate of sale procedure is to be removed from the tax duplicate if the penalty is associated with a delinquency that was not due until after the date of the original tax sale, but is due before the issuance of the certificate of sale by the county executive. Before it said, when a deed is issued to a purchaser of a certificate of sale sold under this statute, the county auditor shall, in the same manner that taxes are removed by certificate of error, remove the tax duplicate, the taxes special, remove from the tax duplicate, the taxes, special assessments, interests, penalties, and costs remaining due as the difference between the amount of the last minimum bid and the amount paid for the certificate of sale. Now, it states that when a deed is issued to a purchaser of a certificate of sale sold, the county auditor shall, in the same manners that taxes are removed by the certificate of error, removed from the tax duplicate, those taxes, special assessments, interest, penalties, and costs remaining due as the difference between the amount of the last minimum bid, and this is where it was added, plus any penalty associated with the delinquency that was not due until after the date of the sale, but is due before the issuance of the certificate of sale with respect to taxes included in the minimum bid that were not due at the time of the sale. Senate Enrolled Act 422. It amends IC 4-6-12-2, -3-4, and it adds IC 4-6-12-3.6. The Attorney General's Office will operate and maintain a tax blight registry beginning July 1, 2015. This is a registry of persons that are described under IC 6-1.1-24-5.3 who are prohibited from purchasing certain properties at a tax sale. And this is a person who owns a fee interest, a life estate interest, or the equitable interest of a contract purchaser in an unsafe building or unsafe premises in the county in which a sale is held under this chapter, and this is to be made available to you. So that should help you to make determinations whether or not somebody would be able to purchase in a tax sale. Senate Enrolled Act 422. It amends IC 6-1.1-24-1-1.5. It adds subsection 23 and IC 32-30-10.6-6. It's effective July 1, 2014. This has to do with vacant or abandoned property. It repeals IC 6-1.1-24-1A2, which had the various provisions about vacant or abandoned properties, such as how that the county executive certifies to the county auditor the vacant or abandoned property for tax sale, and that's to be made 61 days prior to judgment, that type of thing. Now, under IC 6-1.1-24-1.5, the county executive or an executive of a city or town may certify to the county auditor a list of vacant or abandoned property. Before that, the city or town would make that to the county executive. After obtaining an order under IC 32-30-10.6 that the real property is vacant or abandoned, IC 32-30-10.6 applies to a property whether or not that there is a mortgage on that property. It's an alternative to seeking a determination of abandonment under any other statute. The executive of a county, city, or town that has jurisdiction in the location of a property and does not have a person designated as a hearing authority may petition a court for a determination that the property is abandoned. A petition filed with the court under this section must do all of the following: include a statement of the enforcement authority's jurisdiction in the location of the property, allege that the property is abandoned, include evidence that one or more of the conditions set forth in that chapter apply, and a petition under this section shall be served on the creditor and the debtor if the property is subject to a mortgage and any other appropriate party. And it provides either the notices required under IC 32-30-10.6-6, or there's a choice here, or under IC 6-1.1-24-2.3. Both of these are new. It's the same notice that's detailed under IC 6-1.1-24-2.3, but if it's done through IC 32, it is done 120 days before the petition of the court, and if it's done through IC 6, then it must be done at least 120 days before the certification to the auditor. This notice is sent to the owner of record and to any person with substantial property interests of public record. It must give the date of sale, description of property, and that it may be redeemed at or before the abandoned property sale. So this is a big part. The redemption doesn't occur after that it's sold. The redemption has to occur either before it goes to tax sale or on that day. And it must also say what is required for that redemption. If not redeemed, a tax deed may be issued to the purchaser, and that's the whole idea behind this statute, is to be able to give that tax deed right away at tax sale. The notice required is considered sufficient if it's mailed to the last address of the owner as indicated in the records of the county auditor and for the person with substantial interest at the address included in the public record that indicates that interest. And the notice is not required for persons in possession not shown in public records. So there's a lot to that, but really the idea behind it is to be able to get these properties tax deeded and gone. Once this is all done and certified to the county auditor prepares a combined list of the properties certified by the executive of the county, city, or town. You have to delete from the delinquent tax sale list, of course. You provide public notice of the sale of the properties at least 30 days before the date of the sale, auction the property, and issue a deed to the real property to the highest bidder, whose bid is at least the minimum bid required. The minimum bid is the proportionate share of the actual costs incurred by the county in conduction of the sale. So that's reducing that quite a bit. And then the distribution of the purchase amount, as I just said, first goes to the proportionate share of the actual costs incurred by the county. Any amount above be used to pay the costs of the county, city, or town that certified the property for title search and court proceedings. And then any amount remaining shall be distributed to other taxing units during settlement. Senate Rolled Act 422 also adds IC 6-1.1-24-5.1 and -5.4. It requires a business entity that seeks to register to bid at a tax sale must provide a certificate of good standing or authority from the Secretary of State to the county treasurer. If a person purchases a tract that is not eligible under, if that person's not eligible under IC 6-1.1-24-5.4, the property is subject to forfeiture. If the county treasurer determines not more than 6 months later that the property should be forfeited, the person must be notified by the treasurer that the sale is subject to that forfeiture within 30 days if they don't obtain that proper certification. If the person does not meet the conditions within 30 days, the treasurer will refund the surplus amount of the person's bid, and he'll notify you that the sale is forfeited, and you will issue a certificate to the county executive. Now, the treasurer can decline to forfeit the sale, and if they do so, they have to prepare a written statement of why that they're declining to do so and maintain it in their records. And it can't be for just any reason. It does have to have lack of actual knowledge by the bidder, substantial harm to other parties, something like that. .422 also adds IC 6-1.1-24-16. Again, effective July 1, and it's adding paddle fees. The fiscal body adopts an ordinance requiring every person who wishes to participate in a tax sale as a bidder to pay. The fee may not exceed the $25 per person who attends no more than one tax sale in the county in a calendar year and purchases no more than one property. It's $100, may be required to pay $25 fee even if does not purchase property or certificate. If purchased $100 paddle fee, that person is permitted to participate in as many tax sales as are offered that year. If it's the $25 fee. If it's a $100 fee, then they can purchase as many properties as they want, or participate in as many sales as they want. Same thing. Oh, I see what you're saying. I apologize. You're saying just purchase one property. No, it says attend one tax sale. I apologize for that. So they can attend, and it also says purchase no more than one property. So it's the combination of both. Purchase one property and participate in one sale. The fee deposited by the treasurer is deposited no more than 30 days later after the conclusion of the tax sale. It goes into the general fund, and it can only be used to defray expenses of the tax sale, reduce the number, or be used to reduce the number of vacant and abandoned homes, and this could include rehab, demolition, foreclosure, prevention counseling. So, Senate Enrolled Act 422 goes on and on and on. Seriously, when I very first started reading it, I was like, wow, who came up with this? It amends IC 6-1.1-25-4.5. And the purchaser entitled to a tax deed, where it used to state, before it was 9 months after the date of the sale, the purchaser or county attorney, if applicable, gives notice of the sale to the owner of record at the time of the sale. Now it's 6 months, so that timing has changed. And likewise for this next part, after the expiration of the redemption period, but not later than before it was 6 months, now it's 3 months. After the expiration of the redemption period, a verified petition may be filed asking the court to direct the county auditor to issue a tax deed. So, 2 timing changes there. IC 6-1.1-25-11 was amended. And it also amended under this was IC 6-1.1-25-10 that I don't have down here. Both have to do with invalid tax sale of real property. Under -10, it's about before that the court issues a court order to issue a tax deed, and 11 is after. Either way, the purchase money, if it's refunded, would be plus 5% instead of the 6%. And we will change the 17T form to reflect that. Also added was IC 6-1.1-25 20. How many people heard from their county recorders about this? Really? Oh, okay. More hands are coming up because I was going to say that was quite the topic of discussion. They're not happy. I don't think you're going to be happy. Nobody's happy. But there was a reason for this loss, so we'll get into that in just a second. Effective July 1, 2014, a tax deed executed by auditor as a result of tax sale. The auditor will provide a copy of the tax deed to the grantee. The auditor shall collect from the grantee the recording fee on behalf of the county recorder and submit tax deed directly to the county recorder for recording. The recorder records the tax deed in the tax deed records and provides the recorded tax deed to the grantee. Okay. You don't have enough to do, I understand. I handed out, you'll find at the end of the aisles that they weren't passed out to you, the recorder's fees, and so now you're responsible. No, not at all. We had a discussion, a long discussion on this. The law does say that you're going to collect the recording fees, and so that's what you will do. But you are going to have to work with your county recorder on this. We do not expect you to be an expert on all the different fees that they collect in the form that they collect, because these records, they have borders, you know, that you charge certain fees for sizes. There's a whole bunch of stuff. The reason I handed that out to you is just so that you would have something available that not only told you the fees, but also told you which funds that they go into. But again, we want you to work with your county recorder. They are very, very aware of this. Some of them have already said, because a lot of the times, even though tax deeds can come throughout the year, they're usually in groups because of the redemption periods. And a lot of them are more than willing to send a person over to help you with this. And you might, even if the tax deeds aren't standardized in your county, you might want to consider doing this. So here's the process. You will provide a receipt to that person, and you'll complete a report of collections. There are a couple other fees that you do collect in your office, even though that's not something, you know, that you typically do. But you will complete the report of collections, and which will designate the correct funds for these fees. And again, you need to work with your county recorder. And you will send a copy of the receipt along with the deed, so that the recorder knows that the fees have been collected and that they can go ahead and record, because they can't record until they know that you've collected those fees.
Why are we not just having them issue the checks payable to the county recorder like any other deed?
I will tell you what I heard had happened with tax deeds is that this money wasn't getting collected. Now, if it comes into your office, and it says you have to collect, you're fiscally responsible for this money, which means receipting the whole thing. The law says that you're collecting. It's the statute that said, and one of the reasons they're saying this is because, for whatever reason, I don't know if these tax deeds weren't even getting recorded over at the recorder's office. I don't know. I'm not sure about that. I'm just saying that we have to go by what the statute. Now, I will say, if you want to, because this seemed to have been a surprise to the recorders and obviously to you, if you want to talk with your legislative reps about changing this somehow or modifying it, then that's fine. Then that's what you need to do. Yes.
Is there a statute that requires the recorder to collect for deeds? I mean, isn't this statute in violation of another statute? They're statutorily required to collect their own fees.
Yes, but this is specific to tax deeds. And so there is no conflict here. It is saying that for tax deeds, you collect these fees. Well, that's why I said you have to work. The sheet I gave you for the different kinds of fees that are collected tells you, but I don't expect you to be that expert. You are going to have to work with the county recorder. Since this does occur at a certain point in time, then you should be able to have somebody maybe come over from the recorder's office, go through with you to collect these fees, and then to put it into the correct funds. I know this is not popular. Yes. No. Because right, your office has been charged with collecting this fee on their behalf. You've got to deposit it. When you collect money in an office, even though I know that sometimes, and we went through this at the Treasurer's District meeting, sometimes money inadvertently gets mailed into the wrong office, and you might walk it over there or something like that happens. But if you have a situation that occurs all the time, you have a responsibility to safeguard that money. And when it comes to collecting this money, the safeguard is that you deposit it, you're responsible for collecting, you've got a deposit, you got a receipt. It's money coming into your office. That's the way the law was written. Yeah. And I am sorry about that in many ways, because we've always said that one of the reasons that we have the auditor's office and the treasurer's office is so that we have segregation of duties. We know that the auditor's office does collect like the $5 transfer fee. You know, there's certain small fees that you do collect. This is going to be another one of them. You know, again, I understand your concerns. Hopefully you, because at first I thought, well, maybe you could work with your legislator and try to get this figured out. Maybe it wouldn't be a permanent thing, but then I heard that the reason they did this was because these fees were just not getting collected. So there was a reason for it. But again, I encourage you, and I encourage the recorders too, to discuss this and try to see if you can't work out anything. Okay. No. Her question is, will the recorders ever have this on their books? They will not have the fees on their books, but they have to have that receipt, because that's going to say that this recording was paid for. So. Well, she asked, is there a law that says a tax deed has to be recorded? I'm not an expert when it comes to deeds and whether that they have to be recorded anywhere. But to my knowledge, you always record a tax or a deed. I mean, because that's a deed. It's a, no, you don't? Is this where maybe the problem is that's come from? That the legislators were like, well, wait a minute, you're not recording this? Is then this is where the issue's coming in at.
A good idea, but the law doesn't require that.
Well, you know, a tax deed is a new fresh deed. You know, like everything that came before is invalid if it's all done properly. And so now what you're getting into is what you're saying is the first recording. Do you have any thoughts, Tammy, on that?
I was just carrying the microphone.
She is so staying out of this argument. Well, as far as the legality of the tax deed, I'm not going to comment on that side of things. I'm just going to tell you that for those that get recorded, the fees are collected in your office. And again, that might be something else that you need to discuss. I just have a feeling that this is where the whole issue started.
Hang on.
But wouldn't a deed have to be recorded so that way that makes that person to be the owner of record?
That's what I always thought. You know?
Yes.
Huh?
Transfer for taxation only, we do not establish ownership in anything. If we take on this task as auditors, all 92 of us, we have put ourselves in a position of doing someone else's job. It's a dangerous place to be. I say we don't do it.
I think you're missing the point.
Well, here's what the law has set out for you to do, and I think the course of action that is open to you is what I said, is to talk with your legislative reps on this. If you've got issues that this has been placed on you. So, I'm not going to tell you not to be in compliance with the law.
You're just following a court order to issue a deed. The court has taken the legal responsibility.
Okay. Moving on. This is kind of how it was at the recorder's meeting too. I was like, okay, let's move on. Okay. Senate enrolled Act 422 along with the many, many other things that it has done. Also amends IC 32-29-7-3. This is in regard to sheriff's sale. If the sale is canceled, the sheriff will provide written notice to each owner of the real estate. The sheriff will charge a fee of $10 for notice to one owner and $3 for notice to each additional owner for service of written notice. The fee is the cost of the proceeding and collection as other costs of the proceeding are collected. It's deposited into the general fund. It's appropriated for operating expenses of the sheriff's department, and it's to be paid by the person who caused the sale to be canceled. Senate Enrolled Act 311. This one repeals IC 15-20-2, which was the charges to the county for dog killing livestock. Senate Enrolled Act 367 amends IC 6-1.1-24-1.2. It's arranged payment of delinquent taxes before. If the taxpayer failed to abide by the arrangement, the auditor immediately places track on tax sale list, and the taxpayer couldn't make another arrangement for 5 years. Now, if they fail to abide by the arrangement, they get another chance. County treasurer and taxpayer may enter into subsequent arrangement and avoid having track put on tax sale list. House Enrolled Act 1046. This adds IC 6-1.1-12-26.2. This is deductions for heritage barns. You know, I don't talk about deductions unless there's some kind of fee that has to go someplace, so that's the purpose here. County council may pass an ordinance to require a public safety fee for each heritage barn that person receives a deduction for. It can be it's an annual fee not to exceed $50, and it's distributed equitably among police and fire department in whose territory the barns are located. So this fee will be put on the tax bill, and our position is it'll be put on the tax bill, and at settlement time it'll be under the other sources, and much like excise tax or one of those, it'll be put into a separate fund. We've got a fund number for that. We will have all the new fund numbers. There's not too many of them, but there will be a few more added. And we will put that online and notify you of that when those are put online. But for the Heritage Barn public safety fee, it'll go under Heritage Barn Public Safety, Fund number 7306. Since it says it's a territory that the barn is located in, this would refer to taxing districts. So you're going to have one police department, one fire department, equitable, $25, $25. Unless it's less than $50, then it'd be 50%, 50%. So. House Enrolled Act 1075 adds IC 5-10.5-4-2.5 effective upon passage. This is informational for you. In PERS, there's a lot of perf issues this time. It's saying that IMPERS cannot enter into an agreement with a third party before 2017 to provide annuities for retiring members before they were going to start doing that this year. It also adds IC 5-10.5-4-2.6, and this has to do with the interest rates used to determine annuity amounts purchasable by a member who elects to receive as part of their retirement. So right now, it's at, is it 6.5 or 7.5? Okay. But then beginning in October, it will go down to 5.75, and then in 2015, it's going to go to 4.5. So for those of you on retirement, it's had quite the impact at the state and our agency, many agencies, because a lot of people want to get the higher interest rate in their annuity side of things. So I just want you to be forewarned and to have that information. So if you want to try to get in touch with PERF about that. They are quite overwhelmed and very busy. I will let you know that too. House Enrolled Act 1234 amends IC 6-1.1-22-8.1, starting with the 2014 pay 2015 cycle. The tax bills mailed before it was calendar days, now it's 15 business days, and I'm sure Michael will be discussing that tomorrow. And House Enrolled Act 1318 amends IC 3-8-2-7, effective January 1, 2015. This is really informational, talks about declaration of a candidate. Now they have to have a statement that they understand that they may be required to obtain a bond. As you know, we've had some difficulties. People get blindsided by that. So in this statement now they'll know that. and also that they have to have training. I-
What department is responsible for getting that out?
Election division.
The election, okay.
Yeah. House Enrolled Act 1342 adds IC 13-22-12-3.5 while it's repealing IC 6-6-6.6. And really this has to do with hazardous waste disposal. The only thing is that there are few new requirements for the money's expenditure. The money that was in the old fund where these fees got deposited into, that same fund is going to be used, and that's Fund 1221. And before it was collected and dispersed by Department of Revenue, and now it's Department of Environmental Affairs. And this last, I'm not going to spend very much time on. It's just really, the slides really kind of go through the process, but it's just to let you know that for the county recorder, their perpetuation fund is still without appropriation. However, they can have an agreement where, based on certain kinds of criteria, that the money can be expended for general operating costs. There has to be not an appropriation, but an approval of this plan and agreement with the fiscal body. And that's what we're going to expect to see if we see the general operating expenses coming out of there. We're going to expect to see that plan signed approvals by both parties. So I just want to kind of let you know about that.